Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. In this class, we are going to learn the difference between 147 and section 148 of the Indian Penal Code. There are umpteen number of decisions that omnibus charges under section 147 and 148 should not be framed. Section 147 and 148 are distinct offences. They are separate offences, but normally even the courts also, they think that both of them are one and the same. So that is what is observed by on the Supreme Court of India, two judges bench, Sanjay Kishan Kaul and Justice Jasti Charmeshwar. In the case of V.R. Patel, that is Vinu Bhai Ranchod Bhai Patel versus Rajani Bhai Deva Bhai Patel. Gujarati names, definitely Bhai will be there. Right? On 16/5/2018, they delivered the judgment stating that writing with deadly weapons, 147 and 148, they are distinct offences and they should be charged separately, but omnibus allegations or omnibus charges should not be leveled. Right. Now let us know the genesis of 147 and 148. So you may be knowing 143 is unlawful assembly. More than 5 persons or 5 or more persons whose object is to commit a cognizable offence or offences against the same state, they are called as unlawful assembly. If any member of the unlawful assembly uses violence or force, please remember, if any of the members uses violence or force, then it is called rioting, R-I-O-T-N-G. This is punishable under section 147 of the Indian Penal Code. What does 148 say? 148 says writing with deadly weapons. So, if ordinary writing is there, 147. If the same fellow uses any deadly weapons like gandasa, axe or spear, then he is liable under 148. There is a more stringent punishment. So that is the difference between 147 and 148. Force or violence, 147, that means simple injuries. If any deadly weapon is used, definitely it is coming under 148. Now let us go to the facts of the case. This happened in the year 1992. On 11/7/1992, so at about 10 p.m., a writing murder took place in a village called as Nana Ankedia. So in which 3 persons died and 5 persons were injured. So basing on the information, the SHO of the neighboring police station visited the place. Then he noted the injuries, he noted the injured persons. Then he went to the nearby hospital. Then Ameri Hospital, Amreli or Amerli, he visited the hospital and then recorded some of the statements of the injured persons, transferred the FIR to the concerned police station, and as usual, according to 154, the investigation was taken up. So many people, I think 17 people were arraigned as accused. So they were normally, the sections of law are 302, then 147, 148, 326, 323, read with 149, and also Arms Act they have added, and as well as section 135, class 1 of the Bombay Police Act. All these sections have been added. Of course, the accused were arrested, they faced the trial. During the course of trial, some of them were convicted, and most of them, A2, A3, A4, A6, A7 to 9, A11, A15 and 13, they were all given benefit of doubt to the accused, whereas A1 mainly, A5 and A10, they were convicted. Right? Here the main point is Supreme Court, when the matter has come, actually, so even these people at the level of High Court has also gone, the matter has come to the Supreme Court. Supreme Court clearly observed that the charges under section 147 and 148 were laid against all the accused in an omnibus manner, in an arbitrary manner, without having any. You may be knowing section 211 to 212 to up to 214, they deal with the ordinary framing of charges by court. Of course, here the important point is irregular charges need not be taken into consideration unless justice will not be done. So normally it can be, even though the court frames irregular charges, it can be accused, provided if grave injustice is not done. Whatever it is, the Supreme Court found fault with the lower courts in not framing the charges, and also they have found the lacuna in the judgment. Number one, no mention of the unlawful assembly. Simply they have stated they have committed writing like that. They formed into unlawful assembly. Their common object is like this. Then they have done this. In the judgment, it was not at all mentioned. The second point, number of identified. Normally, writing is definitely more than 5 persons. Out of them, what are the overtakes? Who has done which act? Like that, at least oversight. So, number of identified accused were not at all mentioned. And as regards the PMC, that is postmortem certificates, the court just mentioned the oral statements of the doctors who have, so the same statement, but they are not gone into the injuries. Then they have also not critically stated whether all the accused or some of the accused are liable for the death of the deceased person. So to be precise, the charges were not framed correctly. Here, Supreme Court clearly stated regarding the difference between section 147 and 148. Of course, 149 is there. 149 is, in our law of torts, we can call it as vicarious liability. For the act done by one of the members, all of them are liable. 149. Directly, don't say that it is vicarious liability. Just for your remembrance, I am telling you. Vicarious liability comes in civil cases or torts. So please remember. So the Supreme Court remarked, the sessions judge could have corrected at the early stage regarding the irregular framing of charges. So please remember, when large number of people gathered, all of them would not have, only some of them would have committed the crude act or crucial act. So this is the crime. Anyway, since the court could not do anything, already acquitted, that benefit of doubt is already established by the Supreme Court also. Now they said only thing is better to give compensation for the deceased. The three deceased persons, for them compensation was awarded, and also the Supreme Court has come down heavily on the court, on the state, that is state police machinery, in not doing the investigation correctly, and also the lower courts in not framing the charges correctly. So here, what I want to tell you is, please remember, section 147 and 148 are totally different. 147 is, so this is writing. Please remember, if any member uses force or violence, it is called writing. 148, if any member of the so-called right, if the writing is done with deadly weapons, then 148 will attract. Both of them are separate and distinct offences. Please go through the judgment and enrich your legal knowledge. Thank you very much.